Thank you so much for the invitation and for the opportunity to share with you some consideration about where are we now in the field of artificial intelligence and law, artificial intelligence and judicial activity, the difference between digitalization and the use of artificial intelligence. I'll try to be very quick. And now, the first question is, when we talk about artificial intelligence today, what is? What we are talking really about? There is a great debate internationally, and we have people, this is a list of sentences taken from a paper, very authoritative, a nice list of really expert people in the field of artificial intelligence. They say that we are working on generalist AI and we will improve this kind of activity, and there is no fundamental reason for AI progress to slow or halt at human level abilities. So their statement, it is a nice paper published on Science, very short but very clear. They say we are near the possibility of artificial intelligence to overcome human abilities. And okay, a completely different approach says that, okay, till now we have considered generative AI as something that is the first step of a new world, completely new, but this is an authoritative author, let's say, that he says that in 12 months we will see a change of scenario for some basic reason. The current approach has reached a plateau. So the idea that the increase of this technology in the next year will be the same of the past year is not sure. And he says, no, now we are on a plateau. And there is no killer app that is being created. Hallucination remain as a problem. And at the end of the story, he says, okay, we have to think to something more complex. So the criticism is about the linear approach of the first way of thinking. So if we think exactly about the legal field, we see that there is a need of rethinking large language models and the way they are used in the legal field. And there is a growing importance of data quality. Again, every time we have in the development of AI, one day the stress is on data and the other day is on model. And according to, perhaps now we are going back to the stressing the importance of data quality and also the trend towards smaller AI models, okay? So who is right between these two? We don't know. We are not able here, but even the real expert, the people that create artificial intelligence are not sure about what will be the next step. And what they are seeing today is that some very important databases, like LexisNexis, is American, okay, but it is one of the best databases worldwide for the organization in a traditional way, let's say. And they have launched the LexisNexis Plus Artificial Intelligence, generative AI. And they say we can do very nice things like conversational search, document drafting, and summarization. And all this is realized based on very sure data, the data collected and controlled, let's say, in a traditional way. LexisNexis is very huge, but there are also nice small experiences. Daniel Katz, that is a very well-known professor of law in the United States, and Michael Marito, that is a computer scientist, launched Kelvin, Capel 3M, that presents itself as the first database that can guarantee clean provenance, no copyright issues. You know that in the United States there are litigations on this, no synthetic data, high quality content, no breach of contract, no toxic sources. They are very serious and well-known people that we don't know exactly because it's quite recent, the launch of this system, few months. They started on February this year, but the stress is exactly opposite to the stress on large language models. Then there are several experiences in this sense. So who is right? Okay, we don't know. But we as lawyers and we as experts on technology applied to judicial activity, we think that we should consider seriously the possibility of putting ourselves on the safe side, taking care of the quality of data we collect. And so now I present the result of a study we performed with the University of Milan and the IUS Pavia. This is a traditional picture of a case, the materials of a case. This is the level of digitalization, PDF. Okay, oh, digitalization, fantastic, it's the future. Okay, this perhaps is the future. So if we can unpack the content of materials that are simply digitalized and to see inside the small pieces that are the data, that is the focus of our interest. And so this is the project that was funded by the Ministry of Justice. And okay, the aim of the project was to create a new computational object that is capable to collect data from different sources, organize them appropriately in the body of the decision or opinion, so that they are searchable and reusable and useful for AI application. Okay, and the aim was to create something that would be helpful for judges, law clerks, and all people working in the process of judicial taking. This is the group of researchers. And the occasion of this reflection was a reform that was introduced in 2023 in Italy that is called as Cartabia reform. That was the name of the minister, Professor Cartabia. And this legislation made compulsory the use of computer system and digitized files for all the decisions. And all these documents shall be digitally signed and filed in the computer filing system. And also, this is another aspect we do not have time to talk about this. This is the Italian legislation. You do not have to read it. Okay, but what is important are some assumptions and implications. So if all party and judge acts are in digital format, each act of the lawyer, the judge, the trial, and minutes, a judgment is not an isolated document, but is a provisional aggregate of data that come from these different sources. And the effect of digitalization is that the work of judges and lawyers is comparable. They have to work together, otherwise there is no real progress. There are effects also about the sources from which they take the information. and the technology they use, the way the acts are written, how they relate each other, okay, and the technology they use. And so at this level, the digital is not a technological context, but becomes the occasion for a deep transformation of the activity of judges, lawyers. And we need to elaborate a new way of thinking law, because there is something really new. And it is only at this level that artificial intelligence is in the game. Before, we have just digitalization. That is important, but it's different, okay? And so if we consider the decision, the motivation here, I apologize, this is, I didn't find yesterday night, I had an English translation of this scheme, but I didn't find it in my computer. So if we consider the decision of judges, in Italian motivazione or opinion, we see that there is a list of sources. But if we go to considering the piece, the briefs, the writ of lawyers, the sources are the same as the judges. And even the legislator has the same sources, because if a wise legislator tried to understand how to change the legislation, it should be interested in how the previous legislation has been applied, in which ways, and so on. So if we consider all this, how this approach is shared by different professionals involved, we can consider in a practical way how a decision of a judge, this is the structure. Of course, I'll leave the PowerPoint that will be more readable. But this is the segmentation of the decision of judges, and this is the segmentation of the documents by lawyers. They have the same segments, okay? And we took this inspiration from the Rule 74 of the European Court of Human Rights, where it is very clear the comparison between how the ruling is written and how the structure of the lawyer's documents is created. So we can, this is a representation of how many sources convene into the decision of the judge. But at a certain level, we have this is the proposal of our group, research group. We have the intervention of a document builder, because till now, in the blue arrow, we have, let's say, the background of the decision. But there is a moment in the decision where the court, the judge says, okay, these are the positions of the party, but my decision is there. And so we create a proof of concept of a document builder that can help in this sense. I show in 1 minute. We started from a typical decision, 17 pages, okay? A good decision. We reduced it to 1 page, just clarifying the segments of the decision. And then we created a scheme of a decision with the links to data sources. And there is a color code, and you can see in green are the parts you do not have to read, just to have an idea in color. In green are the parts that are already self-filled today. In red, the parts that come from Lawyers Act, and in light blue, the parts that come from hearing record, experts' reports, and so on. But at this point, okay, we need a decision. And document builder is, here there's a very nice video. Unfortunately, we can see, we cannot see now, but it's only in Italian. I'll ask them to translate also in English because it's very clear on how the document builder can work. But the concept is that, okay, we have all these sources that reach the same result of the judgment. And if we consider this is a schematic representation of a repository populated by templates of this new generation. And the ambition is that to clarify that they are all data that are reachable through an algorithm or model that can have the guarantee that this content are exactly the content we are looking for, because we know machine learning had difficulties on this because trying to establish a connection with a proposition if and another proposition then, the problem is that if the if is in the description of a previous level, let's say tribunal, and the judge in the Court of Appeal resumes what happened before, and you have the if in the reconstruction of the first decision, and then you have in the other part of the decision, it is not really helpful. And we can witness that all the studies, we all were engaged on this, were not so helpful. And so we have to, improving the structure and the segmentation of the decisions in interaction with the activity of lawyers and the acts of lawyers will be very helpful. These are the sources of this.
Sorry, just 2 minutes left,
2 minutes,
please.
yes.
Thank you very much.
Yes, just the last section. So we have now the AI Act, okay? The AI Act says that, okay, it is high risk, all the activity that is listed in Annex 3. If you go to Annex 3, you find the administration of justice and say, okay, it is high risk. But if you go back to Article 6, you can see that there is a derogation. And the derogation says that, okay, it is possible to use. It is not necessarily high risk using artificial intelligence for narrow procedural tasks, improve the result of a previously completed human activity, and the AI system is used for preparatory tasks. So it's quite interesting, okay? And I think that all national legislation should follow this scheme. It is not possible. The Italian government proposed a piece of legislation that was clearly against this. But in the debate in the parliament, the situation has changed. They have accepted several of these suggestions. But in my view, the best way would be to take literally this, because if you have a difference between the European regulation and the national legislation, sometimes some problem can arise. So we have a frame that is prudent. It is open and prudent, in my view, at least, because there is a guarantee. This is recital 61, okay? The basic concept is that, okay, the European legislator is concerned with adjudication, okay, which must remain the prerogative of humans. But all the uses that regards administrative activities are not, by definition, high risk, okay? And this is important. The focus is on adjudication. The other point is that, okay, they can be used for support adjudicative activity and avoiding the labeling of a high risk, And we have to isolate the concept of procedural task, preparatory task, and something that can help the previous completed human activity. Okay. So, take-home message.
You need to conclude.
AI is not a monolith that develops in a linear way. So we have to be open to different developments, okay? So in the near future, we can probably see a combination of all the technology, even the expert systems that, expert systems is very remote technology, a combination with generative AI. And if you look on the web, Norm AI, it is a very nice experiment in this sense. We have to improve the data quality because this is still a good investment, even though the generative AI will progress, but the quality of data is very important. The use of AI tools in judicial decision making is not a question of if, but is a question of how. And there is a urgent need to give proper information and discussion about AI involving all society, starting from the universities. It is a desperate situation. I don't know in your countries, but in Italy, the students arrive at the end of the law school that, okay, we have to train judges and to understand, use, and work with. This is more complex. It is easy to say, yes, we have to open to AI technology or we have to reject. No, it is more complex. We have to work with, okay? And so if you want to remain, and this is the end of the story, if you want to remain protagonist of decision-making process, you have to learn and you have to be able to control what is the activity that the machine can offer. Thank you so much.